You just used your U.S. passport to board a flight back home. You arrive at the gate, step up to the CBP officer, hand over your documents, and, instead of a stamp and a quick wave-through, you are sent to secondary inspection. Not because of a criminal history, not because of a visa violation, but because of the other passport in your bag, the one from the country where you were born, the one you have carried your whole life and never once expected would become a concern. That situation is no longer just hypothetical. And if you are a dual citizen, a naturalized U.S. citizen who still holds a foreign travel document, or even a U.S.-born citizen with ties to a second nationality, what is unfolding right now in Washington and at ports of entry across this country is something you need to understand before your next international trip, before your next renewal, and before you assume you are more protected than you really are.
Let us get into exactly what is happening. The idea of dual citizenship in the United States has always sat in a complicated legal space. The United States does not actively encourage dual citizenship, but it has also never imposed a total ban on it. For decades, millions of naturalized citizens and U.S.-born people with foreign-born parents have held two passports without any issue. That level of tolerance is now being tested in ways that are creating real legal consequences at the border, in consular processing, and in administrative reviews. And the 2026 policy climate is pushing that tension to a point that every dual national should take seriously.
Here is how we got here. The shift did not start with one dramatic law. It started with a series of overlapping administrative and enforcement changes that, on their own, looked manageable, but together amount to a meaningful tightening of how dual citizenship is treated in the context of border entry, national security screening, and immigration benefit eligibility. The Department of Homeland Security, acting under its broad authority to regulate the entry and admission of people into the United States, has issued updated operational guidance to Customs and Border Protection and to immigration adjudicators. That guidance treats the use of a foreign passport as a factor that can trigger additional scrutiny in ways it historically did not. At the same time, proposed legislation moving through Congress includes new disclosure and documentation requirements for naturalized citizens who keep foreign nationality. Some of those provisions have cleared committee review in the House.
They have not yet been voted on by the full House, and they have not been taken up by the Senate. That distinction matters. Clearing committee is not the same as becoming law. Passing one chamber is not the same as passing a law. A bill must pass both chambers in the same form and receive a presidential signature before it becomes federal law. We are not there yet. But the direction is clear, and the enforcement climate at ports of entry is already shifting in ways that do not require new legislation to begin.
This is where things get serious. CBP officers at ports of entry have always had broad authority under the Immigration and Nationality Act to question, inspect, and, in some circumstances, detain individuals seeking admission into the United States, including U.S. citizens. Yes, U.S. citizens. Many people do not realize that while a U.S. citizen has an absolute right to enter the United States, that right does not mean entry without inspection. CBP has statutory authority to conduct secondary inspection of any person at a port of entry, including someone presenting a U.S. passport, when the officer has a reasonable basis for extra questioning. What has changed is the trigger for that secondary review. One factor now weighted more heavily in automated screening systems and officer discretion protocols is the known or suspected possession of a foreign passport.
Let us talk about which dual nationals are being affected first and most directly.
The first and most immediately impacted group includes naturalized U.S. citizens who were born in countries currently designated as state sponsors of terrorism or that appear on elevated national security watch lists maintained by DHS and the intelligence community. Those countries include Iran, Syria, Cuba, and North Korea under current State Department designations. But the screening criteria reach beyond that formal list into a wider set of countries of concern tracked through classified and semi-classified intelligence systems. If you were born in any of those countries and later became a naturalized U.S. citizen, but still hold, or have ever held, a passport from your country of birth, you are in a category that is receiving elevated scrutiny at ports of entry right now.
The second group is broader and may surprise many viewers. It includes dual nationals who hold citizenship in countries that are part of the visa waiver program, such as the United Kingdom, Germany,
France, and Australia, but who also hold citizenship in a country that is not in the visa waiver program or that appears on a restricted travel list. The electronic system for travel authorization, which governs visa waiver travel, has long had a rule that disqualifies certain dual nationals from using the program. But enforcement of that disqualification has historically been inconsistent. In 2026, it is being applied far more consistently, and the consequences now reach beyond simply needing to apply for a visa instead of using ESTA. Here is where many people are misunderstanding things. The ESTA dual nationality restriction, specifically the rule that bars ESTA eligibility for nationals of Iran, Iraq, Libya, North Korea, Somalia, Sudan, Syria, and Yemen, regardless of any other citizenship they hold, is not a new rule. It was already written into law under the Visa Waiver Program Improvement and Terrorist Travel Prevention Act. What is new is the downstream effect. In the past, if you were found ineligible for ESTA as a dual national from one of those countries, you would simply apply for a visitor visa instead. That path still exists, but under current consular processing guidance, holding one of those nationalities is now triggering more intense review not just of your ESTA eligibility, but of your underlying admissibility. And in some cases, prior ESTA travel made while a person may have known they were not eligible is now being treated as a possible misrepresentation issue under INA Section 212A-6C. A misrepresentation finding can carry serious long-term immigration consequences. Let me make that more concrete with a real-life example. Imagine a man named Kareem. He was born in Sudan, came to the United States as a student, graduated, worked on OPT, moved into H-1B status, and eventually became a naturalized U.S. citizen. He worked for that goal for years. He kept his Sudanese passport current because Sudan does not recognize renunciation in the same way some other countries do, and he needed it for family travel. He had traveled internationally on his U.S. passport without any problem for several years. Last month, Kareem flew home from a business trip to London. At the CBP kiosk, the system flagged him for secondary inspection. In secondary, he was questioned for more than 2 hours. Officers reviewed his Sudanese passport, which showed recent travel to Sudan. He was ultimately allowed to enter, but a note was placed in his travel record. Nothing official was explained to him. His immigration attorney, after reviewing the situation, believes the flag is tied to the 2026 Enhanced Screening Protocols for dual nationals with travel documents from countries on the heightened review list. Kareem did nothing wrong. He is a U.S. citizen, but his next international trip and potentially his ability to obtain or renew certain work-related security clearances is now more complicated than he ever expected. Kareem is not alone. Now let us look at a second example involving a very different category of dual national, one that has nothing to do with terrorism designations. Meet Elena. She was born in the United States to Ukrainian parents. She holds U.S. citizenship by birth. She also holds Ukrainian citizenship through descent, which she has kept because of family property and inheritance matters in Ukraine. She has never lived in Ukraine as an adult. She carries a Ukrainian passport mainly for administrative convenience when dealing with Ukrainian consular matters. Elena is married to a U.S. citizen, works as a nurse, and has no immigration problems herself. But under the proposed legislative framework currently moving through the House, the one that has cleared committee but not yet been voted on by the full chamber, people who hold citizenship in countries receiving certain categories of U.S. foreign aid restrictions or classified under specific national security frameworks would be required to formally disclose that dual citizenship as part of any application for or renewal of federal employment security clearance or certain immigration benefits, including naturalization applications for family members they sponsor. For Elena, that could mean her sponsorship of her Ukrainian-born parent for a green card through a family-based petition may face extra scrutiny and longer processing under the proposed framework, not because she or her parent did anything wrong, but because the policy structure treats dual nationality as a risk factor in the adjudication process. But there is a very important catch you need to understand. None of what I just described about the proposed legislative provisions is law yet, and that matters a great deal. The House committee process is only the first step in a much longer legislative path. After full House passage, which has not happened yet, the bill would go to the Senate, where it would need to clear the relevant committee, survive floor debate, meet the 60-vote cloture threshold in most circumstances, pass in a form that can be reconciled with the House version, and then be signed by the President. Any one of those steps can stop the legislation completely. Given the current Senate makeup, 60-vote cloture is far from guaranteed on such politically controversial provisions,
And several civil liberties groups and immigration advocacy organizations have already said they would challenge major provisions in federal court if they are enacted, pointing to First Amendment associational rights, Fifth Amendment equal protection concerns, and the long-standing principle that Congress cannot punish citizenship status in ways that create unconstitutional second-class categories. So we are in a period of real legislative uncertainty. But the enforcement climate is already moving separately from any final legislative outcome, which is why waiting until everything is finalized before acting is a mistake many people may regret.
This next part could affect you even if you think it does not. Let us talk about green card holders who are nationals of a second country. If you are a lawful permanent resident and also hold foreign citizenship, the issues I am describing apply to you differently, but still seriously. Your LPR status gives you the right to live and work permanently in the United States, but it does not give you the same re-entry protection as a U.S. citizen. If CBP decides at a port of entry that your admission is not clearly authorized for any reason, including issues connected to your foreign nationality, you can be placed in expedited removal or referred to an immigration judge. The threshold for that referral has traditionally been high for LPRs with strong ties and clean records. But the broader discretion framework DHS issued in 2026 is lowering that threshold in ways that immigration lawyers are actively monitoring and, in some cases, challenging.
Also, if you are an LPR planning to apply for naturalization and you hold foreign citizenship, be aware that the naturalization interview process under current USCIS guidance is now including more detailed questions about foreign ties, foreign government employment, foreign military service, and foreign passport use. These questions have always existed to some extent in the naturalization process, but the depth of the questioning and the consequences of the answers in 2026 have increased. Answers that might have been noted and moved on from in earlier years are now generating requests for extra evidence, delays, and in some cases, denials that require appeal in federal district court. It is also worth noting that protection is not absolute, even for people who have successfully naturalized and hold a U.S. passport. There is a category of extreme cases in which citizenship itself can be challenged through denaturalization. The legal process by which the U.S. government seeks to revoke naturalized citizenship is rare. It requires a federal civil proceeding and a finding that citizenship was obtained through illegal procurement or willful misrepresentation of a material fact. It does not happen casually or without substantial legal process. But the Department of Justice has, in recent years, rebuilt a dedicated denaturalization task force, and the kinds of cases it pursues have expanded beyond the traditional focus on war criminals and fraud cases. Understanding that even naturalized citizenship is not totally immune from challenge in extreme circumstances is part of being accurately informed about the current environment. Now let us move to what you should actually do, because information without action just creates stress. The goal here is always to move from uncertainty toward clarity and preparation. First, if you are a dual national, whether you are a U.S. citizen, an LPR, or a non-immigrant visa holder who holds citizenship in a second country, document your status thoroughly right now. Gather your U.S. passport, your foreign passport, your naturalization certificate if you have one, your certificate of citizenship if you have one, your green card, any previous entry stamps, and records of your travel history from the last 10 years. Keep both physical copies and encrypted digital copies of these documents in a place you can access quickly. Second, if you have traveled internationally in the past 5 years using a foreign passport while holding U.S. citizenship or LPR status, review that travel history carefully with an immigration attorney. Make sure you understand whether any of that travel could raise questions under the current screening criteria and whether there are proactive steps you can take to document the legitimate reason for that travel before you ever have to explain it under pressure at a port of entry. Third, if you are a naturalized U.S. citizen who holds foreign citizenship from a country on a heightened review list,
Seriously consider whether maintaining that foreign citizenship still serves your interests in light of the changed enforcement environment. That is a personal decision, with legal, family, financial, and sometimes safety implications. It is not something to decide quickly or without qualified guidance, but it is absolutely a conversation worth having with an immigration attorney who understands your full situation. Fourth, if you have a pending immigration benefit application and you or the beneficiary holds a second citizenship, make sure your application accurately discloses all nationality information. Missing information or incorrect information in this area, even if it was unintentional, can be treated as misrepresentation under INA Section 212A-6C, with consequences that are far worse than whatever concern you were trying to avoid.
Fifth, before any international travel, no matter how routine it may seem, review the current CBP and State Department travel advisories for your destination and for each country of citizenship. Consider enrolling in the State Department's Smart Traveler Enrollment Program, which registers your trip with the nearest U.S. Embassy and gives you a point of contact if there is trouble abroad. Sixth, speak with a qualified immigration attorney before your next international trip. If you are a dual national in one of the higher scrutiny categories discussed today, even one consultation can give you a realistic picture of your specific risk profile and what, if anything, you should do before departure. Verify any attorney through your state bar association. Do not rely on online forums, social media groups, or document preparers who are not licensed attorneys. Seventh, keep a close watch on official sources, the DHS website, the CBP Travel Information Portal, the State Department's country-specific information pages, and the Federal Register for any new regulatory guidance issued by DHS or DOS. These are the sources that can help you tell the difference between being informed and being caught off guard. Let me end with the broader picture, because understanding where this is going matters just as much as understanding where it stands today. The legislative provisions discussed here are still in early stages. They face real obstacles in the Senate. They will almost certainly face federal court challenges if they pass. The regulatory implementation of any new statutory requirements also takes time, usually months or even years, because the federal rulemaking process under the Administrative Procedure Act requires notice, public comment, and response before a rule carries legal force. So the path from proposed legislation to real-world enforcement is not as quick as the news cycle sometimes makes it seem. But the enforcement changes happening right now, the DHS operational guidance, the CBP screening protocols, and the USCIS adjudication posture do not need new legislation to take effect. They are already happening, and real people are already experiencing them at real ports of entry and in real immigration decisions today. The dual nationals who navigate this environment most successfully will be the ones who understand their specific circumstances, have their documents in order, have qualified legal counsel they can contact when needed, and do not rely on assumptions about protections that are clearly changing around them. Your citizenship, whether it is by birth or by years of effort, is one of the most important legal assets you have. Protecting it in the current climate requires the same careful attention you would give to any major asset. Do not leave it unattended. If you want accurate, timely, and reliable immigration updates, stay informed and turn on notifications wherever you follow trusted legal news. Immigration policy is moving fast, and staying informed is no longer optional. It is essential. If this breakdown brought clarity to something you have been unsure about, please share it with someone who needs it. And if you know a dual national who may not realize how much is changing, send this to them today. What you do not know can create problems you never expected, and what you do know can help you prepare for what comes next.